Good morning, everyone, and welcome to today's webinar hosted by PYA. Today, we are continuing our timely, tough, or tricky physician compensation and fair market value topic series with a presentation on the end of the public health emergency and its impact on physician compensation. PYA is happy to present today's webinar on this important topic. You will have the opportunity to submit questions to today's presenters by typing a message into the question pane of the control panel. We'll collect these and address them by email after the webinar. All of our webinars are recorded and released with a copy of the slides after the event. With that, I would like to introduce Lyle Oelrich and Tynan Kugler, principals at PYA.
Thank you, Laura, and good morning, everyone. My name is Lyle Oelrich, and I'd like to extend a hearty and hospitable reception to this group as we continue to discuss key physician compensation and fair market value topics in 2023. Given the impending end of the public health emergency, we are kicking off our 2023 Timely, Tough, or Tricky webinar series with the discussion of how physician hospital transactions that relied upon the Stark waivers could be impacted on May 12th and the planning that needs to occur as that date approaches. As a quick reminder, the discussion that we'll have here today will focus on general educational topics. And as such, we're not going to be issuing any form of an opinion or definitive guidance, which would be based off of a specific set of facts and circumstances. Today, I am joined by my partner and principal, Tynan Kugler. Tynan works in our compensation valuation, planning, and design department, is located in our Atlanta office, and has over 20 years of experience where she's a regular presenter and author on a variety of physician compensation topics. Tynan also has specific interest in the life sciences industry, oncology, and other strategic initiatives such as black box and provider needs analyses. Briefly, and as for myself, I am also a principal in our compensation valuation, planning, and design department, located in our Knoxville office, have 20 years of experience, and write and speak as well on a variety of financial, operational, and strategic issues facing hospitals and physician practices, such as economic alignment models, compensation valuation, and commercial reasonableness. So to introduce the webinar today and perhaps reintroduce some of you all to this particular webinar series, in 2022, we began knowledge sharing with respect to identified topics of interest related to physician compensation, fair market value, and commercial reasonableness. And I'm happy to report, as in any good Netflix series, the success we encountered with our 30-minute Quick-and-Rs in 2022 led us to be asked back for our second season, which we are extremely pleased about. So here on this slide, you'll see prior discussions that we've had about the 2021 and 2022 Medicare physician fee schedule, telehealth, some changes that occurred in 2022 related to the group practice exception, APPs, value-based arrangements, some nuances related to compensation per work RVU, commercial reasonableness, some of the noise that we're seeing in the benchmark data, physician compensation in rural markets, call coverage, and then we even spoke about, towards the end of last year, the proposed 2023 Medicare physician fee schedule. And if you have any interest in one or more of these topics, I'll ask the moderator at this point to kind of chat in a link to our Timely, Tough, and Tricky 2022 webinar series so you can review these at your leisure. We would like to start our discussion today by talking a little bit about the stark exceptions that were waived and under what circumstances these regulations were waived. Then we'll move on to talk about some of the regulatory changes that have occurred between March 30th of 2020 and May 11th of 2023, and I'll give more clarification on those dates here in just a moment. Since these are the changes that need to be considered in evaluating agreements that relied upon the waivers that are coming to a close. Finally, and where we'll spend the majority of our time today, we'll shift our focus to what entities should be doing to prepare for May 11th. And Tynan will lead this discussion, and we'll conclude by seeking your input on a similar survey we conducted last month, which revealed a list of 2023 timely, tough, and tricky physician compensation and fair market value topics that we'd like to have your input on too. We're really interested in how these issues are impacting your organization, along with any others you may find having additional information to help you deal with on a day-to-day basis. We'll then use this feedback to structure our subsequent timely, tough, and tricky Quick-and-Rs in 2023. So to quickly refresh everyone, and mentioning a couple of dates here in the beginning of the presentation, if we go back to March 13th of 2020, the President proclaimed that the COVID-19 outbreak in the United States constituted a national emergency back to March 1st of 2020. Then on March 30th of 2020, HHS issued blanket waivers to permit certain financial relationships and referrals that would otherwise be sanctioned by the Stark Law. And these blanket waivers then protected those financial relationships when they pertain to at least one COVID-19 purpose. And you'll see those purposes here on this slide, ranging from the diagnosis or treatment of COVID-19 to securing the services of healthcare professionals, addressing business interruption created by COVID-19, and shifting the diagnosis and patient care to the appropriate alternative setting. So by way of example there, certainly telemedicine. And for those of you all who aren't immediately familiar or can't recall some of the 18 types of financial relationships that the waiver applied to, just by way of example, one of them involved the remuneration from an entity to a physician that is above or below fair market value for the services personally performed by that physician. So typically, and as you'll likely know, those have to be at fair market value. But in this case, HHS was allowing arrangements to be paid at greater than or less than fair market value. And in fact, half of these 18 financial relationships, or 9, permitted compensation greater or less than fair market value. They were also bidirectional, which effectively means the compensation from an entity to a physician or the physician to the entity. You'll see here again, loans were permitted at less than fair market value and arrangements not being documented in writing were all permissible throughout the waiver. But a lot has changed since March 30th of 2020. And this slide really can't do justice all of the changes that have occurred since March 30th of 2020, but it begins to outline many of which, for those who may have had a compliant arrangement before March 30th of 2020 and are looking to go back and perhaps use a very similar, or in some instances, we've heard clients think about using the same arrangement that was in place as of March 30th of 2020, really need to be thinking about. And I'm just going to cover these very quickly so we can leave some time to talk about, again, what tips we have for those who need to be addressing these. But related to the Medicare physician fee schedule, and of course, we've had 3 since March 30th of 2020, the 2021, 2022, and the 2023, all of which have had some very significant changes to them. So by way of example, in 2021, we had major evaluation and management work RVU changes, primarily on the outpatient side. But for those organizations who had some form of a compensation per work RVU physician compensation methodology, as you increase the work RVUs, and assuming your organization has implemented the 2021 Medicare physician fee schedule, those physicians are going to be making more compensation now than before March of 2020 because of the work RVUs that have increased, absent any mitigating impacts such as a change in the conversion factor or the like. And in that case, when physicians are earning more compensation, and in some instances, there's little to no change in reimbursement for hospitals who employ physicians, that's led to larger losses for some of these physicians. And by way of example, and this dates back a couple of years now, we had one client with over 500 physicians who was thinking about implementing the Medicare physician fee schedule in 2021. It would have had an impact of over $35 million to that organization. So they would have incurred an incremental $35 million in a loss had they implemented the 2021 Medicare physician fee schedule because of the changes in the work RVUs if they didn't mitigate that in any particular way. 2022 saw some changes too. 2023 has some changes. And in fact, there's some significant work RVU changes in the 2023 physician fee schedule as well, this time primarily on the inpatient side. Quick example, we're certainly aware and have seen some estimates and have done some estimates where hospitalists, for example, seeing patients clearly on the inpatient side may see an increase in work RVUs ranging from 8 to 10%. And again, if you happen to have a physician compensation methodology based off of work RVUs and those work RVUs are going to be increasing, these physicians are going to be seeing an increase in compensation, whereas some other physicians who don't have a methodology based off of work RVUs may not be seeing any or little change in their compensation. Clearly, the Stark Law and the anti-kickback statute have had significant changes. They were effectively modernized on January 19th of 2021. So many changes to get into here, but a couple that are relevant to our discussion today. First, there's a new fair market value definition that came into play with these modernization of the Stark Law. So even if you were compliant prior to March 30th of 2020 and met the fair market value definition, you're not necessarily guaranteed to meet that definition going forward as we think about the end of the PHE because the definition itself has changed. Also, likewise, we now have a codified definition of commercial reasonableness. We did not have that prior to March 30th of 2020. And also, we now have what's more commonly referred to in the industry as the big three, whereas before it was the big two being fair market value and commercial reasonableness, and then the big three, those two plus the volume or value standard. And there's a prescriptive formula that has to be met there to make sure you can be compliant. And the list really goes on as it relates to the Stark and the anti-kickback statute. I do want to mention just a few more comments here on this slide. The survey benchmark data, there is a lot of noise right now in the survey benchmark data. And it really, there's a lot of caution that needs to be used when you're looking at this data. Going back to 2020 and 2021, and some of these are still in play. And remember, because we've got 2022 surveys out right now, 2023 haven't quite yet come out. And so that's based off of 2021 work RVUs when COVID was still impacting a lot of regions in the area. And some organizations made the decision to try to hold their physicians harmless from a compensation perspective, why they had business interruption, and some entities closed their offices where physicians couldn't see patients. And so the work RVU values that they were generating declined. And then if you calculate a compensation per work RVU statistic by way of example, that can be a lot higher because of the reasons I just mentioned. And applying that on a go forward, along with perhaps some of these changes in the Medicare physician fee schedule and the work RVU values, really can be questionable from a fair market value and a commercial reasonableness perspective. Compensation plan changes. Remember as well, for those organizations that relied upon the group practice exception, I mentioned that at the very beginning of our presentation, effective January 1st of 2020, we now have a different regulatory pattern on how DHS profits can be shared. So again, if that was compliant prior to March 30th of 2020, that's now changed. And moving forward beyond May, you may need to revisit that. And then finally, there have been court decisions, there have been advisory opinions, there have been a lot of guidance from the government that has shed light into how the government views these types of situations, and they prosecute them from potential violations as well. So all of these things, and again, there are more that we just don't have time to get into here today, need to be considered as you're preparing to move forward. So at this point, I'm going to pause and turn it to Tynan to talk a little bit more about what entities should be doing to prepare.
Thank you, Lyle. We'll spend the rest of our time talking about a process that we are recommending folks implement, as well as some of the tips and tricks that we've identified to address the best way to prepare. So from our perspective, and we share this perspective with several of the regulatory professionals that we've spoken with about this, that this is an area that's going to be scrutinized at the conclusion of the public health emergency, and honestly, perhaps for years to come. But how quickly this occurs, obviously, is going to remain to be seen. So now is the time to start preparing for scrutiny of arrangements that have been entered into or utilized during this period where we have these blanket waivers. We all know it will not get easier as time goes by. So the process that we're going to walk through is one that we're calling identify, document, and recalibrate. And I realized the letters to that are IDR, which are not to be confused with the independent dispute resolution process under the No Surprises Act. So identify, document, and recalibrate. The first question to really answer is to determine whether your organization used a blanket waiver or took advantage of the blanket waivers. And if you're unsure of that, there are 2 pages as part of the blanket waiver documentation that really provide good examples of how the blanket waivers could be utilized. And as a couple of examples, and there's a whole list of them, but the one example is that a hospital pays physicians above their previously contracted rate for furnishing professional services for COVID-19 patients in particularly hazardous or challenging environments. So that's one example of how you may have used these blanket waivers. Another one is to accommodate patient surge, a hospital rents office space or equipment from an independent physician practice at below fair market value or at no charge. So those are just 2 examples of how organizations may have utilized the blanket waivers. The next step is to really identify all the arrangements that fell under the criteria of the waivers. So first identify whether you use the waivers, then identify any arrangement that would fall within that universe. And one of the things that CMS, a couple of quotes from CMS supporting the need for sort of identifying and documenting, is they stated parties utilizing the blanket waivers must make records relating to the use of the blanket waivers available to the secretary upon request. So as part of this process, they're setting the stage for we know if people use these, we will expect that there have been records that we can potentially go back to say why we used a blanket waiver and have the documentation to back that up. Another quote is that they do not require the submission of specific documentation or notice to the Secretary or CMS in advance of their use. We encourage parties to develop and maintain records in a timely manner as a best practice. So now we're back to the timely part of doing this as we anticipate the end of the public emergency. So practically speaking, the longer the time goes by, the harder it is going to be to document these items. And a really good example that we have talked about is, with all of the changes that have occurred in staffing, organizations, you may not have the same staff today that you did at the start of the pandemic as you did in March 2020. And so it's going to be critical, even more critical, to identify who's maintaining this process of making sure that you've identified and documented, and who's going to keep a history of those records on a go-forward basis. So one of the other challenges is identifying, once you've looked at this universe in an era where we all have limited time, stratify those arrangements by risk levels. So the higher risk arrangements are the ones that you will want to start looking at first. And specifically, you'll want to look at what changed, why that change was made. And an example of a change back to the CMS example is, did you increase physician compensation? And if yes, why? And if the answer to that why is still present, is it still present or did it subside? And so there's some questions that you're going to need to answer. One of the things that we did early in the public health emergency is publish this blanket waiver documentation checklist that you see here. I'm going to ask the moderator to post a link to that, but that's a document that we were using to help identify whether you could meet the waiver, but it's also something you could utilize to determine whether you've got the right documentation. So that's a really handy tool to be able to go back to as you think about the identification and documentation. So the third piece is this recalibration. And as Lyle mentioned, there were 18 waivers, and 9 of those 18 waivers, or 50%, involved paying above or below fair market value. And so we anticipate that a number of arrangements that relied upon those waivers will need to be reevaluated from a fair market value perspective, but also from a commercial reasonableness perspective. And Lyle did a good job of going through all of the reasons, in addition to what you may have done as a result of the public health emergency, why those need to be recalibrated. So the importance on the commercial reasonableness side is, when we talk about fair market value, we're talking about, dollars. So it deals with the amount of money that's exchanged between the two parties or parties to a transaction, whereas commercial reasonableness examines the business purpose of the arrangement. And when we're talking about the PHE and the business purpose being related to COVID-19, that's the reason why when you're looking at your documentation, looking at why you're still entering or why you still have this arrangement is going to be equally as important. So stratifying is going to also be important here from a CR perspective, and identifying the ones that are sort of your highest risk and prioritizing what you need to do between now and May 11th, knowing that as of May 12th, that documentation is going to need to be in place, and those arrangements are also going to need to have been recalibrated if necessary. And we all know that process takes time, both from a legal review perspective and an external review perspective if that's needed. And so begin planning now. So let's talk through just a couple of other tips, and many of these are also included in the blanket waiver documentation. But education is key, making sure that everybody that may have touched an arrangement is on board with what the process is, what the requirements are. If there's loaned equipment, that's another area. So if there's loaned equipment that's gone between two parties, especially to physicians, making sure that loaned equipment has been returned as appropriate. There's a provision for non-monetary compensation and other incidental benefits that are also critical to take a look at. And then there's a good example about loans that have been made to physicians. There's one specific to anesthesia, and the preference or was a loan to an anesthesia practice to offset lost income. You have to look and make sure that those loans are, don't have more favorable terms than lenders who otherwise wouldn't have a physician referral relationship, and then making sure that that there's facility growth capacity is approved, and that there are also those writing and signature arrangements. And, at the end of the day, if you determine that you can't meet an exception or you aren't able to bring an arrangement into compliance, then there's the decision that has to be made about terminating an arrangement. So one of the other things we thought would be helpful is to just briefly walk through a client example that we had. We've actually worked with a health system that's had an arrangement with a private multi-specialty physician practice for a period of time, and it relates to radiology services, where the hospital provides a complement of PACS workstations and related IT support services to the physician practice. This arrangement has been, in play long before the public health emergency, and has at all times been, fair market value up until then. But with the pandemic, what happened is, in the provision of more remote work that shifted to the radiologists, there was more equipment and more services that were needed by those radiologists and that practice throughout the public health emergency, and the hospital was able to take advantage of the blanket waiver to expedite the provision of that equipment and those services. And so one of the really interesting things for us has been that this particular organization, both the health system and the practice, have been really proactive about working collaboratively to make sure that that arrangement for which they utilize the blanket waiver is coming back into compliance from a fair market value perspective. So each time there's been a public health emergency end announcement, they have proactively been trying to get that arrangement back into a compliant fair market value, from a fair market value standpoint, and to have it documented. So it was a good example for us of a best practice, in that it was top of mind. So just in brief summary, identify if you used a blanket waiver, identify the arrangements that have been affected, ensure that you have appropriate documentation, recalibrate or reevaluate the arrangements, and then, in the interest of time that the clock is ticking, begin now, use the available resources and processes that you already have in place, and prioritize those high-risk engagements or arrangements. So the final slide, before I turn it back over to our moderator, is, and Lyle teed this up at the beginning, here's a list of the 2023 topics we have identified as being top of mind by several folks that we've surveyed. We are going to put up in the chat box a 30-second, it will take you less than 30 seconds to complete. It's a survey that will walk you through these particular topics, and in an effort to help us prioritize what's of most importance to you all. And please feel free to include any others that we may have missed. We'll circulate that survey with the materials after the webinar, and they'll also be available on demand. But we really appreciate your participation today. We appreciate your feedback. Please let us know if you have any follow-up questions. And with that, I'm going to hand it back over to Laura Smith.
Thank you. And thanks to our presenters, Lyle and Tynan. If you have any questions, their presentation and contact information will be emailed to you, along with a recording of today's webinar. Also, if PYA can provide assistance with audit, tax, compliance, valuation, or physician services, please call or email us. You may also visit our website at pyapc.com for more details about our specific areas of expertise or to subscribe to receive PYA insights. On behalf of PYA, thank you for joining us and have a great rest of your day.